Hello?
Hello.
And let me see here. Miss Corey, did we have, you heard from the parties?
And after lunch. Yeah, we can bring it.
Pardon me,
Here, and I'll go over it with you.
there's someone talking.
Just a second.
Hear you.
You did. Okay. So in the gall matter, have the parties contacted you?
Yes, I've been in contact with both parties. However, in this particular case, even though the kiddos live out of town, pretty substantially out of town, I feel the need to visit them in person rather than by Zoom. It's difficult with children over Zoom. And I actually have that planned for later this week.
Okay.
Ms. Gall is county pay. Mr. Gall is private pay, I believe. Have not seen any payment as of yet, but really haven't had that discussion with him. So.
Okay. And but you've been in touch with both parties at this juncture?
Yeah.
Okay. All right. So, Mr. Gall, you need to work out that issue with the guardian and get that taken care of.
Yes, sir.
Let me see here if I got, I think we have, that was really, I think all that was on for today was to make sure everybody was in touch with you. And we've got a review hearing on March 26th for an interim report. So hopefully that'll be sufficient time for you.
Yes, I hope so.
Okay.
Thank you.
All right. So I think that's all for today. And then we'll see you back on the 26th unless we hear something else.
Yes.
Thank you, Your Honor.
So I put this on, we're actually on next week for readiness. I put it on Mr. Birnbaum. We were on last month for trial. We struck trial because Mr. Birnbaum didn't have contact with his client. We spoke last week and he was in that same position. I didn't want to then just wait until readiness to address it. And so it looks like his client is on the Zoom today. And so I guess I'd turn it over to Mr. Birnbaum on whether or not we're proceeding forward.
Thank you, counsel. Yeah, I just had contact with Mr. Bagweezen this morning for the first time in a little bit here, Your Honor. It's currently set for trial for the week of March 4th. Because of the lack of contact I've had with Mr. Bagweezen, I'd like the court to maybe entertain setting out the trial date once again in order to make sure we can have this matter fully prepared for the court.
And my issue here is that we already did that once last month, based on the exact same circumstances. My client shouldn't have to be in the position where Mr. Bagweezen sort of comes and goes as he pleases from this court matter. My client has a right to have the case heard. It's a 2021 cause number. At some point, we need to get it done. We're ready to go forward. And if they have contact at this point, it's one thing if there's still no contact, but there's contact now. There's time to get ready. My preference is we leave the trial set as it is, and we'll address it next week at readiness.
And just a brief response, Your Honor. I don't think the parties will be prejudiced by another continuance in this matter. I would indicate, just for the record, that we were provided with an amended petition that was filed on February 13th. So my client should have an opportunity to review that petition and answer it in a timely fashion.
Just looking at, was there a motion to amend in this case?
No, not yet.
Okay, so that's not formally before the court then?
Correct.
And again, Your Honor, there are a lot of issues involved with this particular relationship. And I just want to make sure that we can be fully prepared for trial as far as getting through the multiple issues with these parties.
Well, my thought is this: if we've had some challenges with communication, I'd be inclined to leave it on for readiness next week on the 27th. And depending upon it, after you've had a chance to speak more with your client, if there's a good reason, the judge at that time can take a look at it and make a decision about whether or not to continue.
All right. Very good. Thank you.
So,
I'll
thank you.
leave it on for 11:30 on the 27th.
Yes.
Okay.
Thank you, Your Honor.
You're welcome. I see Mr. Roberts is present.
Yes, I am.
So some things have changed and some things have not since filing this motion. So the motion is to get Mr. Roberts to participate in a CR26I. He did participate in a CR26I. We're still in a position where he has not addressed the CR 41 issue. Case has been pending for almost a year now. And with Mr. Roberts sort of, again, kind of coming in and out of his own case. And so at this point, what I'd ask the court to do is he did participate in the 26I. I'd ask the court to set it out to March 12th. We'll see sort of where he goes from there, if he addresses the other issues that need to be addressed or not, and then we can review it and I can provide the court an update on the 12th.
Excuse me. So you're just simply asking to continue this hearing to the 12th?
I think that's a reasonable way of addressing it.
Mr. Roberts, it sounds like you're at least addressing some of the issues. Any objection to just setting this hearing out to the 12th, and you can work with Ms. Baldwin and see if we can get this resolved?
No, that's what me and Miss Baldwin talked about the other day. So
Okay. So if you
I
can,
was in court. I was in court last time we had our meeting, but I didn't know it was on Zoom. I was sitting in the courtroom and
got it. Okay. Well, you're here
Oh.
now. We've got that on the record, so you're definitely here
Yeah.
today. So I'll set this on and you can appear either in person or Zoom on the 12th. We have both available. So
Okay.
the 12th at 1 o'clock, and we'll review it. And if everything is resolved, feel free to strike the hearing counsel.
All right, very good. Thank you, Your Honor. That's that
So
for this
I
matter.
won't be
Okay.
entering an order today.
No, you won't.
okay, thank you. Bye.
You're welcome. Let's see here. Do we have a report on that one? Looks like that was filed on the 16th.
It was, and Mr. Lawrence did provide that for us. I did forward a copy of that to my client for her review. We have emailed back and forth this morning and over the weekend, and not confirmed face to face or really gotten any depth beyond just the initial emails back and forth. Doesn't change a lot of things. We do have that parties were in anticipation of a mandatory settlement conference last month, weren't able to get anywhere because we didn't have that report. Commissioner at the time did indicate that parties are free to reset that or proceed as they wish pending the outcome of that. So I think that's the position largely we're in today. I'm not sure we can do a lot. There's no formal motion before you, and frankly, we just got the report one business day ago.
Mr. Beam, there's nothing pending before me to make a decision on today. So this is just to make sure everything's done. It looks like the report's out. So if you and Mr. Zandy and his client want to chat and see if you can come to resolution, you're certainly free to do that. If you want to set another settlement conference or mediation, just let us know. We can make those orders. Okay. That's all today.
Thank you.
Georgia Petrie for Brittany Krakenberg, Your Honor.
All right. And where are we at on this one?
I think we're here just for the GAL interim report today.
And
Yes, Your Honor, that's correct. I'm Heather Kale. I'm the guardian ad litem on this case.
Okay. I don't see a report in the file.
I have not filed a paper report, but I'm happy to do a verbal report for you if you'd like, Your Honor.
Probably a written report's probably more appropriate for the parties so they have notice of what we're talking about.
Okay. Could we do a holdover and I'd be happy to file that?
Sure.
Okay.
How much time do you think you need?
If I have 2 weeks, I'm good to go.
Okay. Council available on the 5th at 1 o'clock.
Sorry. Let me just check real quick, please.
Ms. Bliss?
Yes, that works for me, Judge. Thank you.
Okay, so set it over 2 weeks to the 5th at 1 o'clock. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Judge.
Looks like we had a response filed, so I assume the default is not moving forward.
Yes, Your Honor, that's correct.
Okay, and there was an order that was filed for presentation on our hearing the last time. Did you get a copy of that, sir? Mr. Fowler? Mr. Fowler, can you hear me? Mr. Fowler, I'm going to ask, maybe have you log out and log back in again if you can hear me, and we can come back to this in a minute. Let's see if that makes a difference. Sometimes things hang up. So we'll come back to this in just a minute. Let's see if we can get him logged in. Ms. Gilmore is present.
Hi, Attorney.
I have Mr. Zandy in the courtroom, and I think I saw both parties.
My client's present via Zoom, Your Honor.
And I think both parties are present via Zoom, so I see them both. Okay. So counsel, go ahead.
Okay, thank you, Your Honor. As court's aware, I do represent the respondent in this matter. We're here on my client's motion for some financial relief. I think the pleadings submitted by both parties detail what the concerns are. I'll be brief in my comments. But just mainly this is the result of a 7-year marriage, a 10-year relationship. Parties were married back on November 26th of 2016, recently separated back in October, which is where the 7 years plus the 3 that they dated, making this, again, the 10 years that I referenced previously. There are no children born as issue of this marriage. However, the parties have always been, to both of their credit, deeply involved in the foster care system. Have a little boy, Weston, who was the intent since they got Weston, who's born into drugs and substance abuse, as of September of 2022, that they wanted to adopt this young man. He's now 2.5 years old. My client details for you, it's largely undisputed, some of the issues that Weston has had, but he's largely in her care. This matter comes about as the husband had a change of heart pertaining to the relationship, decided that he wanted to pursue other endeavors, essentially telling my client, we're done, it's over, and you need to make other arrangements. My client has thus told you in her declaration, it came as a shock and a surprise to her. These parties recently, and again, just prior to him making that decision, purchased a home together in Longview. The parties, again, have continued in their efforts to adopt Weston, and Mr. just says, well, I don't want to do that anymore. Gives my client the option of having Weston again, which she tells you in very specific terms, lives with her. She's continuing through that process. He has essentially told the licensors in the state he's no longer interested in that. My client now has moved to a rental dwelling in Longview at the rate of $1,600 per month with Weston. Again, trying to live inside of her means, which is difficult when you're paying rent. Also a car payment of $400 and essentially living off the credit cards now that were paid off in the car accident prior. Mr. spends a lot of time in his responsive pleadings going through the analysis of this car wreck and where money went and where it didn't go. I think that's largely not germane to the issue today. This is a case in which you have 2 spouses who, again, devoted their lives to each other for a period of time, in which the husband makes over twice what my client does. If you look at the income information from him, and again, it was pretty close to what we estimated at the onset of this case, he's making about $105,000 per year compared to my client's $50,000. We provided you information from my client's employer stating that she works about 28 to 30 hours per week. This was by design of the parties. So again, she could be readily present with foster kids who these parties agreed to take under their roof, and again, to both of their credit. My client has been consistently employed. It's interesting to point out, again, when we're looking at RCW 26.09.090. My client is realistic with this, and she tells you that. She does not anticipate, she does not expect any long duration of maintenance. We're not requesting that. My client details for you, she just needs some money on a transitional basis to help stay afloat until she can essentially figure things out. She's currently getting the money from the state. Again, it's undisputed. That gets reviewed every several months. And this is a child who requires almost $9 per specialized milk because his body has undergone what it is, and he's got allergic reactions and issues physically with a lot of the foods. Can't eat gluten. This milk that he requires, again, this is a child who's 2.5 years old, drinks a lot of milk, who goes through those routinely to the point of a couple $100s per month. The income, as Mr. recalls it, is not income. It's essentially reimbursement from the state, again, which is reviewed every 6 months or so. So again, if you're looking at that, you take that out of the equation, you're looking at the 2 parties, and you've got a husband who's making well over 6 figures per year. You've got my client who's making about $50,000 per year. My client is, again, very specific in her request. We believe it is reasonable for the court to award her some kind of transitionary support. We've suggested an amount of $1,000 per month to extend 12 months. Again, given the 10-year relationship, the 7-year marriage, completely reasonable. And again, I think that kind of speaks to where she's at with this. She's not out trying to take advantage of the situation. You don't get that. That's not evidence through the pleadings. This is somebody who just needs some help to get established. If you look at the cost that she's undergoing, she's got the $1,600 lease payment. She's got the $400 car payment. She's got the costs for Weston. She's also got the phone plan. She's got the insurance. She's got all these new utilities. She's got all these new costs that she's going to undertake. And if you look at the other side of that, Mr. doesn't have that. Mr. is living in a home, again, that was recently purchased. Mr. has his mortgage. He has some credit cards. That's about it. If you look at the past, again, I think this is important when you look at the totality of these circumstances. These parties got together, and what did they do? They both contributed about $30,000 to pay off a prior 401k loan that he had in his name. That was his
Well,
separate.
I have objected to consideration of any payment towards the loan. I think that's a bigger issue for property division, but that was contained within the reply. My client didn't have the opportunity to respond to that. I don't think it's a huge issue, but it was contained in the reply.
Yeah, I'm not sure that that's relevant to the
And again,
current
it
situation.
doesn't really matter. This is everything that's kind of gone into this. Again, through the course of time, this is one where there's a disparity in incomes, where husband's making significantly more than the wife. And this is a case where she's asking for the financial relief cited in our motion. Also asking for $2,500 in temporary fees and costs. We would ask that any award be paid within a date certain. We've suggested 60 days within entry of that order, so that my client again can help pay for the legal expense and hopefully get a resolution to this sooner than later. But where we sit right now, some support on a limited basis, again, for a limited duration of time is appropriate given the circumstances.
Just for some clarification before I hear from Ms. Gilmore, does your client's income expense detail anything about the adoption funds or expenses?
Are you asking me?
Yes.
No, it doesn't. That's the reimbursement that we've got in there. I've used her income based off the past W-2s for that. Sure, and again, I think it's uncontested. I think both parties, the one thing they do agree to is she is getting those reimbursements from the state. But those again are all prospective to these reviews that the state has. That's also been.
This is Michael Beck-Wiesen. Please give me a call at 253-355.
Sorry, go ahead.
So they're subject to these reviews periodically. My guess is, and again, knowing the system, that once this child is adopted, that could again change. So the reimbursements are what they are. Money from the state is what it is, but that's based on the foster care that the child's currently under.
My other question is are the expenses that she's got in her declaration, do those include the child's expenses or are those some?
No, so we left those largely out. She's getting the WIC, she's getting the monetary award from the state based on that. Again, is the reimbursements.
Okay. All right, Ms. Gilmore.
I'd just like to know, I don't agree with that. I needed to pull up the financial declaration itself, but I can make some argument. But I do believe that the child's costs were encompassed within the financial declaration. I think that she did even list itself in the section regarding child's expenses when coming to the $3,600. But again, just for the record, Megan Gilmore on behalf of the petitioner and non-moving party, namely Nathan Kingus. The parties were in a short-term marriage from November of 2016 until their separation in October of 2023. The parties were not in a committed intimate relationship as evidenced within wife's own responsive pleadings. Regardless, an allegation of committed intimate relationship is not contemplated when the court is awarding temporary support. And we believe wife improperly attempts to sway the court in her effort making allegations of fault in a no-fault state against my client. My client adamantly denies abandoning the party's foster son, but rather wife has cut him off of access to this child. And frankly, we don't have really any jurisdiction in this case to even really be discussing this child, as the dependency court has control over visitation rights in support of this child. My client denies that wife was blindsided by this dissolution or he had threatened her anyway financially. To the contrary, wife was verbally abusive during the marriage, which she acknowledges and apologizes for within her correspondence attached within our responsive declaration.
I mean, I'm going to say any fault attributed towards verbal communications between the parties, that's largely irrelevant.
Right. This is a no fault state. So.
Danny brought it up, but I'm happy to move forward. Despite wife's comments, in reality, the parties remained amicable after separation. Wife moved out of the home on October 19th of 2023, then returned to the home in mid-November. As also confirmed within the parties' communications attached within our responsive materials, the parties were working together and agreed to share in the household expenses until the home could be sold based on the agreement of the parties. Wife then unilaterally rescinded this agreement and moved out on January 5th. Wife left the home with nearly all of the community personal property. Wife was able to
object to anything that's settlement negotiations and the party separated. That's not permissible in court.
All right. Well, it's in all the declarations, but if we can just focus on the temporary issues, please.
The temporary, he was asking for division of personal property, so I can move forward if the court's going to award all assets in my client's possession, but that's the reason for the argument.
Okay, I
didn't understand what she said.
I didn't think that was contested, but
It was my understanding that Ms. Kangas wanted access to the home to have additional personal property. We have subsequently did an additional exchange of personal property. So if it's not an issue that we need to be making any sort of additional transfers, I don't need to be making arguments about personal property. But that was the basis of the argument.
Okay, I didn't see that in the responsive declaration, so.
Okay, we are just asking the court award my client on a temporary basis all personal property in his possession, including his tools and bikes. Also, issue was a bank account. The parties community via a federal bank account with the last 3822. My client explains in his declaration that the parties by agreement divided this account in December, and each party received $2,800 from the joint account. Looking to the parties' incomes, my client's gross annual income for 2023 was $103,853. I divided this by 12 months, which gave him a gross monthly income of $8,654 or a net income of $5,453. This is an average income, obviously, and my client's pay stubs show that his actual income is often below that average. The average includes a $5,000 bonus that the parties received in June of 2023 and spent during the marriage. Again, my client's average income is often lower than the actual, and that's set forth within the pay stub that we presented to the court. Wife also made argument regarding my client's retirement contributions. These were set during the marriage and are not substantial. My client's annual contributions are in line with the statutory minimum allowed with child support, but again, this isn't a child support case. For child support, the court must look to the actual income of the parties when awarding temporary support. My client's overtime is acknowledged within his pay stubs and W-2. My client does not work overtime 2 to 3 times a month. This is another allegation that was contained within the reply declaration that my client didn't have the opportunity to respond to. As set forth within his financial declaration, my client has an estimated budget of $5,342. The mortgage alone is over $2,500. My client continues to have weekend visitation with his foster daughters, and he doesn't receive any sort of support for these children. There was some discussion in the reply about vehicle payments. My client's vehicle has over 310 miles. Again, simply won't last longer in this case. Despite wife's comments, it seems we are agreed to sell the community real property. My client will not be able to afford the necessary improvements if wife's request for spousal support is granted. My client's financial declaration doesn't capture all of the expenses that will be necessary to ensure that the home can be sold at a price high enough to cover the current mortgage. My client is living paycheck to paycheck as he solely covers the household expenses despite the parties' previous agreements. Wife mentions vacations within her reply declaration that again, my client didn't have access to respond to, but she fails to report that my client went to California. This trip was paid for prior to the separation. He went to California to see his son who's in the military.
I'm going to object to anything not contained in the pleadings.
All right, we just limit to the pleadings, please. Hold on a sec, you're breaking up real bad there. That's clear, yes, go ahead.
Then I would object to the consideration of the new information contained within the reply. There were suggestions that my client had the ability to go on vacations and had excess of income contained in the reply, and that's the basis for my comments.
Okay.
Moving forward, looking to wife's incomes, wife has worked and developed her career throughout the marriage. There was some suggestion in her reply that she stayed at home, but that frankly isn't true. Wife has a gross annual income for 2023 of $51,939. I divided this by 12 months, which gave her a gross of $4,328 or a net of $3,530. Wife conveniently fails to disclose within her financial declaration, within her motion and her reply, the fact that she does receive state assistance. There's no indication whatsoever that this is going to go away, and frankly, if anything, would increase. As filed under seal on February 13th, wife receives a monthly income of $1,740.
To the introduction or attempt thereof of these documents that were submitted well after my client submitted her reply. There's no explanation for what they are. I think everybody agrees she's getting state assistance. I think in my comments, we just talked about that, and I do think it's contained in the declaration. So I'd ask you not to consider, Judge, anything that was filed after Mr. Kangas's initial response of pleadings. I think that's pursuant to the local rule.
Well, I think what I've been looking at are just the pleadings. I'm looking at your declarations, your financial declarations, which is
thank you,
kind of the focus.
And this information was provided by Mr. Zanny's office. It's just simply confirming the exact amount that she received, which again is $1,749 from the state assistance. If the court adds her work income with her income that she receives from the state, her total net.
Again, same objection. That's information that was presented in these documents that nobody had a chance to respond to, and they were not clearly expressed.
Okay. Well, there was mention of the of the state money in some amount, I think, in the
Correct.
declarations. So
Correct. But not, I just ask you don't consider anything that was filed about a week or so ago on this. I think
I'm just
that's,
looking at the documents that were filed within the timelines.
yes, thank you.
Based on the information contained within our declaration, wife has a net income of $5,200, which is again identical to the net income of my client. You must add and consider for the purposes of spousal support both the income that she receives for her work as well as the state income. There's simply no basis to ask for this to be excluded. And there's no indication this is in some way temporary. Based on the actual income of both parties, there's simply no disparity of incomes at this point. Wife also fails to establish a need. Wife has an alleged budget of $3,600 that she files within her financial declaration. I ask the court to look at the financial declaration. It does include all expenses for this child, but again, it does not include the state assistance that she receives and fails to mention the fact that she receives WIC for the food that she alleges is so high, as well as the fact that she receives free daycare so that she can work a full-time job. Also, I think for the purposes of support and fees, the court must consider the fact that wife received over $10,000 from a motor vehicle accident involving the community vehicle. All of these funds, it's undisputed, went to wife, which she used to pay off her credit card, which frees up her income to live. Wife allegedly had so much excess income that she had an ability to allegedly donate some of this money away, as she indicates within her declarations, tithing. Wife also fails to acknowledge that the funds left over from the motor vehicle accident that she currently has in her bank account. Her current bank account has over $4,000 in it. We have no documentation suggesting that wife has outstanding medical bills or how much those will cost. Wife has an ability to seek compensation from the driver that was at fault, which she fails to mention. And again, it's just an unknown expense that we don't know if it will ever exist. Given the lack of need and ability to pay in this case, we ask the court to deny the request for spousal support. As wife received all of the community funds from the car and half of the bank account already, and frankly, by the fact that there's simply no pot of money to go around, we ask the court to deny the request for fees. Lastly, we ask the court to the parties to share in the improvement costs for the home which is required prior to being put on the market. Alternatively, we ask the court to compensate my client with separate income and labors he puts into the home following this order. Thank you.
Mr. Zandy.
Yeah, and briefly, I'm not certain where the submission that my client has provided this information when it's clearly contained throughout the pleadings. I'll start with the obvious. Mr. is claiming that he's got a $2,500 per month mortgage. Again, that's going to go away very soon. The parties agree to sell this house. That's gone. It relates to, and again, counsel keeps calling it income for Weston. It's not income, it's reimbursement. If you look at my client's financial declaration, and again, this is pretty clear, the only thing she has on there, it relates to the diapers for the child that she has at $100 per month, as well as clothes at a very modest amount. That's the out-of-pocket cost for that. What's not included in there, and to answer the court's question, is, again, let's just start with the specialized milk. This says $8.99, and it's less than a gallon. It's not very much. Child goes through several of these per month. So if you look at my client's food budget on there, again, it's very modest from what is typically expended. This child alone is going through several $100s per month in just milk. That's not included in the specialized foods that are gluten-free. That's not the special dietary needs. None of that is included. And again, it's not included because that's not income to her. She is not a nurse. She is not getting paid for that. That's through the foster care support. So these misnomers that Mr. is paying $2,500 mortgage, again, it was his intent. He did this without my client's knowledge. Decided I'm going to sell the home when he decided that the marriage was over. He went so far as to contact a longtime friend to list that home. Again, we're fine with that. We agree with that. That's probably the most prudent thing to do. Have no way of knowing at this point what these parties are going to receive for that. What we do know is that since separation, he's done nothing on that house to make any of these improvements as suggested by the realtor. The income is what it is. The suggestion, the W-2s, the historical earnings show my client earning about $50,000 per year, showing that Mr. makes in excess of $100,000 a year. To try to say that those incomes are the same, again, just is not borne out by anything in front of you, and that's about as creative math as I think you can possibly get. So looking at the reality of the situation, my client certainly has a need, and she's proven that to you. That need is only going to increase now that it's just her income in her home with a 2.5-year-old child with special needs who was a drug-addicted baby upon his birth. The fact that we've got Mr. whose expenses are going to go down, who's getting ready to sell a home and making in excess of 6 figures per year. Again, there's clearly a disparity of incomes. There's clearly a length of a duration of the marriage that warrants a request for some financial assistance. And this basically comes down to his comments to her, which was what? And she details this for you. I'm not going to pay you anything outside of a court order. Here we are. Thus the motion, thus my client's response for some kind of help to get through the transition of going through a separation, which frankly surprised her. And she's got 2 mouths to feed. He has 1.
All right. Well, I think that a couple of things. I would agree that the money coming from the state for the adoption support or whatever, well, first, a couple of things. I don't think this court has any ability to do anything related to that child as long as there's a dependency and no waiver of jurisdiction, if that's somehow part of this case. However, that being said, seems to me that we need to look on a temporary basis. We look at the expenses of the household and we look at the money available in the household. It may not be income for purposes of anything, but my concern is that if the declaration that I have, and I don't know, the concern is you're indicating that this expenses for her, that food and for the children is not the actual amount because there's this other money coming in. And that makes it a challenge for me to make an informed ruling as to what her actual need is. I don't know if I don't know the number, but it sounds like it's somewhere between 1,000 and 18. I don't know what the number actually is, but let's say it's 1,000. If she's getting 1,000 from the state to help take care of this child, and it sounds like there may be some other resources, and there's not an additional $1,000 of expenses that aren't listed here, then I'm not sure why we're talking about that. So we would be looking at her income is about $400 less than her expenses that she's got documented here. His income is about $100 more than his documented expenses, just going off of the financial documents. And granted, he earns a lot more money, but right now he's paying more expenses by quite a bit. And I recognize that once that house sells, his housing expense will significantly change, but we don't know exactly what that's going to look like. And until that happens, it is an expense that needs to be paid for both of the parties to receive anything. There's also I assume, some expenses for work to be done on the house to get it sold. Obviously, our housing market is not as good as it was a year and a half ago based on the interest rates. But so I don't know anything about the house or anything. That's really no way to even discuss the likelihood of that happening in the next 3 months or 6 months. At this point, I mean, if I look purely on need and ability, it's pretty close, frankly. And again, not having that information about the other child, frankly, my inclination is just to set this over a week or so and have you update showing what reimbursements are coming in, what specific expenses that the Weston has that's different than on this list, so I can make an informed decision about that. So that'd be my thought.
Can we go out, if we're going to do that, can we go out at least 2 weeks?
Yeah, I have no problem with that. Any objection to going out to the 5th, Ms. Gilmore?
I'd just like to know for the record that she is the moving party. She has an obligation to provide this information before the court. She could have provided it in the reply. So I would be apprehensive about agreeing to set over, but I do understand the court's direction. For 2 weeks, I would be free on is it March 5th?
Be the 5th, yeah, at 1 o'clock.
Okay.
And in the short term, the request as far as each party maintain their own personal property that they have would be appropriate, and not change any insurances or that sort of thing, or dispose of assets.
So specifically what we're looking for on the 5th is information about what Weston's expenses are being paid from the state.
Well, if there's additional expenses here that are not included for him, and however much is being received from the state.
I see.
Okay. I mean, I don't know if he's got $500 additional expenses or $1,500 additional expenses. And again, not knowing what the state's paying, that does make a difference. And I agree, counsel, this is not income for purposes of like calculating taxes or anything like that, but it is money in the household that's paying expenses of the household. So,
okay, I will get you what we can. I assume Mr. Kangas will do the same.
Okay. And so if you want to hold off on doing the rest of the temporary, or you want to do a short-term temporary that awards the personal property that they each have to.
Yeah, I don't think we disagree with that. That's fine.
Okay. All right, so reconvene on the 5th at 1 o'clock. And if you can get that to me ahead of time, I should be able to have your decision pretty quickly.
And if we get you that information, since the arguments aren't going to change, you can just do that to save these parties money in chambers.
I'm fine to do that if you
Give that
want.
to Skillmore.
Yeah, that's fine. No, that's absolutely fine. And I'll present the meeting.
So I'll need my information, we say a week.
Sure.
Good.
Sure. And then I have, sorry.
And then if you want to respond to that, and then I can just do it ex parte unless you want to have another docket again.
No, I don't think we need another doc. You've heard the arguments. I think that's probably sufficient.
Yeah, I agree. That's fine.
All right, thank you.
All right, thank you.
Just to clarify, my response, any response will be due, what, 4 days after Andy's?
Mr. Zandy, by next, how about like by next Monday? That's the 26th.
Sure.
And then Ms. Gilmore, if you could have yours in by the 1st, which is next Friday.
Yeah, that works. Thank you.
Very well, thank you.
Thank you. Gotcha. Very good. Okay, so the default is not going to happen today, so that'd be denied based on the response. I already talked about that. Did you receive a copy of the proposed order from the hearing the last time we were here, sir?
Yes, and I sent opposing counsel back some edits that I would like, and I'm waiting a response.
Okay, Ms. Holder?
I have not seen anything related to the presentation of orders from the hearing that happened on the 13th. So Mr. Fowler has sent me some things regarding what he would like to see in a parenting plan, but because the parenting plan was not ruled on, he hasn't filed an official response. We did ask him if that was for settlement, and he agreed that it was more for settlement than anything else. So if he would like to address that with the court, he's more than welcome to, but it didn't have to do with the presentation of orders that we sent him.
Okay. What I'm specifically talking about, this was at least filed with the court on the 13th, and what the order says is that you'd be providing responses to interrogatories by February 16th. There was a $1,700 that I awarded at the last hearing, and that may be paid out of the joint bank account. So that's pretty much what the order says.
Gotcha. Yes, I received that. I'm currently at an inpatient treatment facility, and so access to a lot of the records and information I do not have access to. So I filled it out to the best of my ability and returned it. And then once I am able and have access to my home computer with those documents, we'll send them over.
Okay, well, I guess my specific question is the order from the last hearing, do you have any objection to that?
No, I missed the hearing. I fully accept that, and there's the ramifications behind it.
Okay. I don't know that I saw an original of that order. Maybe I did here. Just have to check. So counsel, if you want to forward an original of that order, I'll be happy to enter that unless that's already been done.
Okay.
And what else did we have?
Your Honor, if I remember correctly, you wanted to address the issue of a GAL. We had put forward forward a proposed parenting plan along with the motion for temporary family law orders. And Your Honor was okay with the amount to withdraw from the bank account for spousal and child support, not that $50,000, but that my client could withdraw $3,000 a month out of the joint checking account. And if there was the spousal support and the child support out of the joint checking account, but not the lump sum of $50,000. The other issue that the court wanted to address specifically was the issue of a GAL. If I remember correctly, Your Honor was unsure about wanting to put the proposed parenting plan in place due to the restrictions that were placed on father. And we agreed from the hearing from 2 weeks ago that this would be the more appropriate time to hear that. And instead of tacking on another court date, we would just hear that issue today.
Looking back on my notes here. Well, we sent it over to see if a default would be granted. That was the reason I didn't issue order JL.
Correct, Your Honor. And now with the default not being granted due to Mr. Fowler's participation in the proceedings due to his response to the marriage petition, how would the court like to go forward with the other proposed items that we had previously put before the court?
Well, as far as a JL, if it's in dispute, the parenting plan is not agreed to, then we probably need a JL.
My understanding, and Mr. Fowler can correct me if I'm wrong, is that there are some things that are in dispute regarding the terms that he would like in the parenting plan. I don't think there was any issue as to his disagreement about custody or anything of that nature. If a GAL is to be appointed, I would ask the court to appoint it based on a very narrow scope of questions designed to get to the issue of how does Mr. Fowler's sobriety impact his ability to parent.
Now, let me see here. Sir, did you file a proposed parenting plan?
I did not file. I'm fairly new to this. I apologize. I will work on that.
All right. Well, looking at your response, you're asking the court to enter your proposed parenting plan. I don't know what that looks like. So I need to see that. Depending on what that says, how that compares to the petitioners, may or not need a guardian ad litem, but I don't know what exactly you're asking specifically.
Okay.
So my thought would be, if you're not that far apart and it's not issues that really need to be looked into by a GAL, we may be able to either do it with an investigator or just have the court handle it. But I guess I'd like to see that specifically, because I don't know what your requests are as it relates to the proposed parenting plan from the petitioner.
Your Honor, if I may, and if Mr. Fowler would be okay with it, I do have what he objected to in the form of an email that he sent to me. They're relatively minor issues. I wouldn't say they're minor issues. They're minor in the fact that they could be addressed very easily with this court. It's up to Mr. Fowler if he would like for me to, I don't want to represent him as an attorney, but he did send me some of the things that he specified. And if he does not have access to some of his documents, I would be happy to bring that up for the court for Mr. Fowler to address.
By all means.
Well, if you want to, I guess, file those so I can take a look at them, it's fine.
Okay. In that event, Your Honor, would you like to set over this hearing again so that we could allow Mr. Fowler to respond?
Well, as it relates to the parent, whether we need a GAL or not, I guess my thought would be is go ahead and file either the emails or a proposed parenting plan from him, so I know exactly what the differences are, how large those are. I could probably, do you know when you're going to be out of inpatient, sir?
I'm currently set for the 12th, but treatment is going well, and I'm asking for a 2-week extension to the 26th.
Okay. And do you have access to computer access and a printer there where you're at?
Limited at best, unfortunately.
Okay. The reason is you can download a parenting plan from the state court website and fill that out and send it in. That would probably be the best alternative. But if you believe that you've addressed your concerns in that email, that could simply be filed, and then I'll just have that, and I can take a look at it and determine if we need a GAL or not.
I did. The email I responded with has my primary concerns in the parenting plan.
Okay. So why don't we put it over to like maybe 2 weeks to the 5th, and if you want to file that, counsel, I'll have that in front of me, then I can make a decision about the GAL.
And Your Honor, if we could go back to the motion to compel on the order, I still have not received full discovery from Mr. Fowler. He has responded to the interrogatory. Some of them are complete, some of them are not. I have not received any documents. I do understand that he's in inpatient treatment currently. I don't necessarily think that we should keep setting this out every time for a motion to compel until I get full discovery. I think that's a waste of the court's time and of resources for the parties. So what I would ask is that we can get because if I'm not mistaken, the court also set over the motion to compel was set over a week, but because I've not received the discovery yet, I'm unclear if the court wants me to file another motion to compel or if I can just create a new order based on today, because the 37B findings, I think it would be appropriate in this case to not set any more hearings out, but to just ask that if I do not have documentation from Mr. Fowler in the form of the request for production and interrogatories by May 1st, those just cannot be used in evidence for the trial that's coming up.
May 1st is a date that I can certainly make.
Right, that seems appropriate. That'll get him out of the inpatient in time to respond as needed. So, yeah, I think an order to that effect is probably appropriate.
Okay, so my question would be the proposed orders that we've already put in front of the court that have not been signed off, would Your Honor be amenable to me just adding that provision that anything not provided by May 1st may not be used as evidence at the trial as a form of a sanction?
I think that's fine. So the order that we talked about earlier today, sir, that included that $1,700, she would be adding a line to that that indicates that you'd need to respond, have all the documents to her prior to May 1st, or else you wouldn't be able to admit them at trial.
I understand.
Okay. All right. So yeah, go ahead and just add that in, and that could be sent ex parte per entry.
Thank you, Your Honor.
I think that's
Yes,
everything.
thank you, Your Honor.
Is that everything on this one that's pending? Yeah, I do want to review it in 2 weeks on the GAL issue, because we don't want to let that, I don't want to wait till May 1st to do that, obviously. So I'll review it on the 5th at 1 o'clock, and I'll probably just do a bench order on that if it's going to be, we can talk about JLs if we need to. So I would need both of you present on that in case we decide to go that route.
And that's 1 p.m. on what day, Your Honor?
On the 5th, 2 weeks from today. I assume you can get that email cover sheet and then filed in the next few days.
I can file that, Your Honor, if Mr. Fowler would like my office to file that, as he does not have access to records right now.
I would greatly appreciate that, and thank you.
I think that's going to facilitate moving things forward more quickly. So if you can do that, I'll take a look at it on the 5th. We'll make a decision on the JL or not, and then go from there. And we could put, I'll enter the order that we just talked about ex parte as soon as I see that.
Okay. Thank you, Your Honor.
Okay.
Thank you.
You're welcome. Last matter. I see Mr. Olmos is present.
Yes, Your Honor.
A second here, Miss Tina. Are you? There we go. Okay, got everybody here.
Sorry, I'm at the drug court graduation. It's mandatory.
Okay, so if you can just step, are you out in the hallway now, or? So this, and just so you both know, I did not have this until sometime after noon because it was not on my docket. So I've had a real cursory opportunity to look at the documents. And I do note there is already an existing protection order, and that has some real specific visitation rules. So Mr. Olmos, it looks like these are all your motions, and I guess let me just kind of inquire about them. You've asked for a restraining order. Are you asking for something different than the protection order that's in place?
I was asking for a restraining order through the family law.
Are you asking for something different than what's been granted in the other case?
I believe I was in the documents, but I believe we can stick with the supervised visits as they've been through the parenting and unlimited phone calls. I would just like the order extended up until things have been resolved.
Let me see here.
And I do apologize, Your Honor. I do work from home, so I'm on Bluetooth, but I do have my children in the background. So
what I'm looking at, looks like there was an order entered in the restraining order case that essentially allowed specific professionally supervised visitation up to 3 times per week, 2 hours at a time, but no less than 2 times per week. And parties allowed to contact with mediator to present mediation, parenting plan mediation. So that's in the restraining order that's currently in effect in the other case. So if you're simply asking that be rolled over into the family law case, that probably, that makes sense. I'm not sure there's a need for that since the other one's in place, but we can do that. It doesn't really, are you asking for a change to those parts of the terms?
not necessarily, but I have been having issues with the contacting by the phone with her. I work from home and I have 4 children that I take care of.
Mm-hmm.
And I've tried telling her, sometimes I'm just not available. And then what she's been doing is she's been saying, okay, well, I'm going to call every 30 minutes until you answer. I'm going to call every hour on the hour until you answer, you know, and then I get these hateful messages and, you know, and I'm doing my best. And I've tried to explain to her that, you know, I'm not always available. Like I work from home. I use my phone for work sometimes, and I'm just not always available. I've recently bought a new phone so my children can just use that phone for contact with Samantha, but it's began to get quite harassing, and I just kind of want to simmer it down and just maybe, you know, work out something in the restraining order to where she, you know, isn't constantly calling me when I'm telling her that I'm not available or the children aren't available.
May I say something, Your Honor?
Sure, go ahead.
So calls will be scheduled, and I do have all evidence of all of our text messages. I can submit those if you would like me to. A visit, like a phone visit, will be scheduled, and he will 5 to 7 minutes before that video visit. I'm busy right now, or something's came up, or there's always some type of excuse regarding speaking to the children. When I did get granted unlimited video visits, I did make it a point to call them every day, random times a day, like morning, night, good night, hello, what are you eating for lunch? If I'm not in class, or if I'm not busy with a meeting or anything like that with my sponsor, I am trying to talk to the children, just because I was a very consistent mother in their life prior to all of this happening. I did write Judge Hahn a letter. I don't know if you've had a chance to take a look at it. If not, I do have a copy of it. I can read it to you. That explains the situation and the gravity of our relationship. This whole thing, like, I do take full accountability for putting my hands on George, but I have never once, the false allegations against my children, which I have been arrested for, I am in drug court for, I do feel are just another form of control to control me. There's multiple text messages where he is trying to tell me I can't wear this, or I can't do that, or he's going to turn off the card. And this is in a 6-year span of our relationship. There is prior court dates where George states on record that I'm a great mother. He knows I'm a great mother. I fully believe this is to intentionally hurt me, and to intentionally have this last bit of control over me, because near the end of our relationship, he stopped having that control over me. I started setting boundaries, and I started saying no. I never had been away from my children prior to this. I do feel like I'm being alienated against them. My 2-year-old is just now starting to warm up to me again. Like I told the commissioner that I would do anything. Like, I'll jump through any hoop. I'll do anything. Today I'm phasing up to phase 3 of drug court. I just got in November 22nd. The only I'm kind of spewing out a lot here, but the only reason I admitted, or I had to admit guilt to the harassment in the 1st degree charge, was to get into drug court, because all my other charges aren't felony charges. With that being said, all of my other charges are SOC'd or on a deferred prosecution. So I'm doing everything I'm supposed to be. Again, like I said, I do feel this is a form, his last attempt to control me. He said that, well, I'll agree to go to mediation, but you need to agree to giving me sole custody. And I'm just like, how is that mediation? You know, like, that's not mediation. That's you trying to bully me into giving you full custody. I just want us to share our children. We both love our children. We had a very toxic relationship. He's hit me. I never pressed charges. I've hit him. He pressed charges. I've never, ever, ever intentionally hurt my children. Have I slammed a finger in a door on accident? Yes. And I fully regretted it. Have I pulled their hair a little too tight when I'm making, I'm doing their ponytails? Yes. And they don't like it. Or I sprayed them with the water with the, doing their hair. I don't know. I wish if it's okay with you, I would like to read this letter that I did prepare to Judge Hahn for you.
I think it was filed. It was filed. It looks like this is the one. Looks like it was filed as part of your response on February 16th.
Yes, sir. Which I also, like I said in my declaration, I have videos where of interactions with me and my children. At times when I didn't even know I was being video recorded, and I have tons and tons, and I'm talking thousands upon thousands of pictures and videos of my babies, like all of them, all 4 of them, even the one that I didn't birth, just happy and content. And I was always there. The only reason I'm not there now is, well, again, because I put my hands on George, and I do admit to that, and I do admit that it was wrong of me and I shouldn't have done that. But this whole taking the children away and keeping them away, when I served him the first response, which was which had his abuse in it, it had his psychological, his the physical, the mental, everything was submitted between text messages between him and I. He then stopped letting me talk to the kids. Like when I got granted that first 2 weeks, like we were talking all the time. He didn't have any problems letting them talk to me. Once I got granted that, or once I had him served for that, the visits were few and far between. I mean, it went from me not being able to talk to him or see him at all for months, Your Honor, because I didn't understand the law. I didn't understand that I could appeal the video or the protective order. And I really feel, had I not missed the court day, which unfortunately I missed it by a half hour, I actually called that Monday and I'm like, hey, I'm just checking to make sure, the court date is at this time on this day. And the lady was like, you missed it by a half hour. He won by default. And I'm like, crap, and since then I've been trying to get it changed. I've also been doing everything I can. And I do want to let you know that him responding to me, harassing him, these are all this is all advice. My sponsor, who is a victim, a child's advocate, or who used to be a child's advocate, that is who my sponsor is. She has 20 something years clean. She's the one who's been walking me through this process. It has been very difficult. And my children consistently tell me, I want to go be with you. I want to see you. I want to stay the night with you. Like I mean, this is a consistent thing that they are saying. And like I said, if you review the pictures in there, I mean, you have pictures from our recent visits of how happy my babies are, to way back in the day, before I even had my youngest son. I mean, they were all consistently happy. If you look up my Facebook, you're going to see nothing but happiness. I mean, yes, sometimes I would post, like, we had issues with our oldest son, well, his oldest son, excuse me. He has behavioral issues. So we had a lot of issues with that, but again, we were addressing it through therapy for the children. My oldest has issues regarding her father and whatnot, and so we were doing that through therapy. I don't want to have anything to do with George. I want us to share our babies equally, because I know they both need us, as long as we are both healthy and sober individuals. But this control, it's just a control thing, sir. And I don't know how to combat it except with what I can show you between our 6-year relationship. I mean, there's a ton of stuff in there that, like, not a normal person who doesn't control what their spouse wears or who they see, or if I go spend something on the card, or if he's mad at me, he shuts off his credit card. This is when I was a stay-at-home mom. He would do things like that and then think it was funny, and I submitted those text messages, because there again is that's financial abuse. Like I reacted like horribly to the abuse, and I stayed, and I should have never stayed, but I wanted to for our children, and I wanted to try to make it work. And I thought it was something that, hey, if we do this, if we both set our boundaries, if we do, that it'll be okay. And it didn't happen that way. And I don't want to say hate myself for it, but I regret not taking the steps to leave, what's the word, amicably.
Okay, thank you. So
Your Honor, may I have a chance to speak?
You can. I was just going to mention, I did see that letter that was attached to the response, so that I did review that earlier. So, Mr. Olmos, go ahead.
Your Honor, I have no want to drag Samantha's name through the mud. I know that our relationship wasn't perfect, and I have no desire to go over our relationship. My only concern is the children and their safety. Samantha claims to have never abused the children. However, on May 28th of 2003, she was charged with assault on Cheyenne. That incident just briefly. Samantha was getting drunk. Shandon threw it with me. She's the oldest kid. So it's always me and her picking up the pieces when Samantha's intoxicated. I have no, I believe fully that Samantha loves her children. I have no doubts about that. However, Samantha has extreme mental health issues and addiction issues. When Samantha gets angry, she resorts to self-medication like alcohol or dust off. That particular moment on May 20th of 2023, she resorted to alcohol. Samantha Cheyenne requested for her to stop drinking, begged her mom, please mom, don't drink. I don't like it when you drink.
Okay.
It
Well,
resulted.
Sir, let me stop. I need to have you focus on the document, on information you provided in documents. I didn't see that anywhere specifically in the declaration.
I did provide that in a declaration. I provided all of her charges.
No, I did about the steps from the daughter. I didn't see that anywhere. Maybe I missed that.
It's the assault for on May 23rd. It's on the declaration page.
No, I understand that, but then there's a lot of details you're giving about what the daughter has done and said in it. So I need to focus on you filed written documents, and that's what I'm limited to.
Sorry.
Yes,
as far as
and like I understand, Your Honor, and that's what I was saying. I had no need to. I've been trying to avoid dragging her name through the mud, sending all the text messages and things to that nature. But essentially, there has been physical abuse towards the children. That is she's been charged with. There's the felony harassment, where she threatened to kill the kids. There is the assault for when she hit Cheyenne, the assault for on me, and also there was a crime committed on July 4th of 2022, where Samantha stabbed me and was charged with assault 1. However, at that time, I didn't want to press charges, so I dropped those charges. And I can submit more documentation if needed. I have all the information. I just was not trying to drag her name through the mud. I thought it was a pretty open and shut type of issue. But Samantha has a long history of drug abuse and mental illness stemming from quite a while. After I met Samantha in 2017, she was charged with distribution of methamphetamines on April 3rd of 2018. She was charged with distribution of methamphetamines, and she took a plea bargain for it. I'm just trying to establish your addictive behavior.
I didn't see all that in your declaration.
I understand.
So that's what I'm working with. Here's where I'm kind of at on this. I think we probably, you requested this go to mediation, which I'm guessing isn't going to be all that successful given the circumstances. And I don't know that the mediators will take a case with an active protection order. That being said, probably the best next step would be to get a guardian ad litem appointed to look into, talk to both of you, talk to witnesses, and get a report back to the court as to what's appropriate for a
Yes, I did
parenting plan.
request that.
I mean, that would be my normal process at this juncture. There's a lot of issues going on, obviously, and I think without getting that input, we're going to be in a place where we're not going to be able to get it to an end result. So that would be my thought today, based on reviewing the documents today, listening to your arguments today. Again, I'm concerned. I mean, I'm happy to send it to mediation if you think there's a chance of that working, but I guess what I'm getting back is that's likely to not be too successful, given the issues between the two of you. And again, I'm concerned about with the active protection order, whether they'll even take that case. Have either of you reached out to the mediation center or any other mediators to see if they would?
I requested, Your Honor, for us to be able to allow mediation through the restraining order. I think you mentioned that towards the beginning.
I saw that.
So when I reached out to the mediation center, that was my first stop. They mentioned that we would need something in the protective order to allow us to do mediation.
Mm-hmm.
You may be right as far as it may not be successful, because I do want to have full custody to make sure my kids are safe. And if Samantha's not in agreement with that, you know, and obviously the mediation's not going to work. My main concern is my children's safety.
As are mine, as well as their emotional well-being and their mental, their mental well-being. I know that this separation with me has definitely created a barrier between, especially me and my youngest son. I would love to have all of my children with me. And again, I'm doing everything I'm supposed to be doing. I've had one mess up when it came to drug court, and that was it. And that was back on December 5th. But like I said, him stating we can go to mediation, but she needs to agree to full custody. That's not mediating anything. That's telling me, okay, well, if you don't do this, then it's not going to happen,
Okay.
And
Well,
that is why, go ahead.
That's why I'm saying I think probably I just need to get a guardian ad litem to look into this to make some recommendations to the court. It doesn't make sense to have you spend money trying to do a mediation when there's really not a likely outcome that's going to be successful.
And another issue I have is I'm having to pay for these supervised visits because it wasn't a CPS case, it was a civil case, which is very, is hard on me financially. I have rent to pay, just like I only work part-time. I clean houses for a living, and with everything that I have going on, I mean, drug court, my treatment, my sponsors giving me the opportunity to do 90 and 90, and so that's that's a big thing. And it's getting a little hard to be able to do that.
All right. Well, and I understand that. So, and sir, I'm looking at your income and expenses, and it looks like you're kind of upside down as well.
Yeah, I take care of 4 children by myself with my single income. I have a decent job, but it doesn't equate to much with the amount of people I take care of.
Okay. Give me a second. Let me get the names of the mediators or the guardian ad litem.
Sorry, Your Honor.
No, you're fine.
Your Honor, if I can bring up, I did have a chance to look at his financials as well. And he is withholding the truth about some of his financials. His mortgage payment is not $1,700 a month, because I was with him when we bought the house, and what he told me I was there when we got the electric bill and all these bills that he's claiming are super high up. I don't doubt that he's struggling financially, which is why I'm like, hey, let's do this 50-50. We'll all pay for my.
Let me stop you for a second. This is only about whether or not you have to pay for the guardian ad litem. That's the only issue right now. Okay, I'm not dealing with child support or anything else that's not in front of me. Who's next?
Karen Lawrence is next, John.
And they need 3 though. They get 3 choices.
So it'd be Karen, Ann Height, and Keith Lawrence.
All right. So the people that we have currently available would be Karen Lawrence, Ann Height, or Keith Lawrence, and you each have an opportunity to disqualify or strike one of those if you don't want one of them to hear it. But we start at the top. So if you're both agreeable to Ms. Lawrence, she would be the next in line. If you're not, then we would go down the list. So either you have a problem with Ms. Lawrence?
I've never met neither one of them, I don't think.
Mr. Olmos?
You mentioned that there was Keith Lawrence.
There's Karen is first, and you each get to disqualify one person. So you'd be looking at either Karen Lawrence or Ann Height at this point. Because she's not disqualifying. So
and if you could just briefly explain, so this individual, from my understanding, just goes and checks the situation and then determines on custody.
They're going to talk to each of you. They're going to look at all of the CPS records, protection order records, criminal records, treatment records as applicable, all those sorts of things, and then come back after doing all that and give the court, whether it's myself or a different judge, a report recommendation as to what a parenting plan should look like given your history and kind of where you're at now.
Okay. Sounds perfect.
So are you comfortable with Ms. Lawrence or?
Yeah. And you said we have an option if for some reason we weren't comfortable. We have one strike.
You need to tell me that now, though. It's not after. Oh. So if you got a problem with one of these folks, you can speak, but then we just go to
yeah, no, I'm not aware of any of them, so
okay,
it should be fine.
We'll appoint Ms. Lawrence, and I think based on what I know, based on a court file of your incomes and expenses, I'll have that at county pay at this point. And so I'll get an order put together on that. She will need to probably have each of you sign some releases of information because since you're not currently here in court, I can't have you sign off on that on the order. But I will get that order done right after court and get that to her. So she'll be reaching out to you. And do we have in our file good contact information for both of you?
Yes, sir. Your Honor.
Yeah, it looks like I've got, let's see here. Let me just double check. I've got everybody's email and information. So we'll give her that information. So she'll be reaching out to you, and then we're setting some review hearings on these to make sure everybody's following through. We go in 30 days. I'll set a review out.
And Your Honor,
yes.
What was the response regarding the temporary family law order, the temporary custody order?
Haven't got to that yet. So
Okay.
give me just a second. Let me get this in place. So I'll set a review March 19th at 1. That's on this docket Zoom hearing. That's just to make sure that you both follow through. Ms. Lawrence will be there to let me know that she's got all the information she needs at that point, and then moving forward. And then I think we're setting a couple
Your
of
Honor,
reviews. Yes.
you said March 1st?
March 19th.
Oh, March 19th. I'm sorry.
No.
At what? At 9 or 1?
1 o'clock.
1 o'clock. Okay.
That's a Zoom hearing on this docket. That's just a review to make sure you guys have followed through and that she's got the information she needs.
Perfect.
And then
He won't ask for the same thing that he wants in the actual parenting plans for the temporary orders. So
just a minute, man. Let me get to where I'm at here to get me confused. So I'll set an interim on May 14th. That'd be at 1 o'clock, and that'll be a Zoom hearing. That's for an interim report from the Guardian, and then we can set a final. I think those are those out? How far are those going out? Do you remember off the top of your head? I think I'll go into July.
sorry, I was adding that to my calendar.
Okay, and then I'm going to put a final report on July 13th, also at 1 o'clock. That would be an opportunity for her she'll have her report filed at that time or be requesting some additional time if she needs it. 13th?
Is a Saturday.
I'm sorry?
Your Honor, could I request
Oh, I'm
having
sorry.
at least
16th.
the children for the weekends?
Well, on a temporary basis, until I get at least something back from the Guardian, I'm not inclined to make any changes to the current plan that's set up in the protection order.
I was also able to add in the reports, well, what they have given me from the supervised place.
I saw those.
And I was going to request more today, but I knew I had to be at this hearing as well as the drug court graduation.
So on the temporary orders, my inclination would be to maintain exactly what's currently set out in the protection order until I have more from the Guardian. And so that essentially would be the nature of the temporary parenting plan. It would have those same visitation pieces in it. As far as all of the findings that go in, as far as at the top section, I would defer on those until I get a report back from the Guardian ad litem. That doesn't mean I'm denying them. I'm just not making a finding on those until I have more information. And then on the, just a second here, let me look at your petition. And again, I have to apologize because this came in kind of late, so I've got to refresh my memory. So as far as the child support issue, I have your information, sir. I don't have yours, ma'am. So what I would need is to have you file a financial declaration that shows your current income and expenses. And that's a form you can get from our court website if you don't have that.
Your Honor, she works under the table, so there's not going to be any sort of documentation of any sort of financials.
Okay, I need to have her declaration as to what she makes, sir.
Yeah, I understand.
Whatever she provides me is what I'll be working from. And so as far as child support, I think what I'll probably do is set that out a couple of weeks so I can at least see that declaration to work from.
Thank you, Your Honor.
So let's see, what's the 5th look like? Come on. Do you know what the 5th looks like as far as, I think I'm going to go to the 12th of March at 1 o'clock, and I'll take a look at the child support. So ma'am, I'll need to have you file that written financial declaration that sets out your income and your expenses under oath. Provide a copy of that to Mr. Olmos, but if you can get that done by, say, this time next week, then I'll have that for docket on the 12th. And that'll really be the issue that I deal with on the 12th, is what child support should be set at.
Okay.
Okay?
And that's at 1 p.m. as well, Your Honor.
Correct, 1 p.m. on the 12th. So we got a lot of hearings I just gave you. Hopefully you've got.
Yeah.
I've been typing them.
Why don't we do this? Why don't I put that on the 19th as well, so we don't have a hearing every week for you? Does that make sense?
Yeah, that sounds great, sir.
Okay.
Or Your Honor.
Is there any way that since I'm having to pay for, if George could also help pay for the supervised visits?
Oh, well, at this juncture, I don't have any financial information. I'd need to take a look and see what you've got, and I'll need a formal motion to look at that.
Okay.
But let's put that on the 19th for the child support, any other financial issues at that time.
And that's March 19th.
March 19th, that's also that review that we set for the guardian ad litem. Okay. So I've got 3 hearings, March 19th, May 14th, and July 16th. And I think I may have given you the wrong date in July earlier. I was looking at a wrong month there. It should be July 16th at 1 o'clock.
Okay.
And that will be set out in the guardian ad litem order that I'll put that together right after court. I think it'll be easier for me to get that done than have one of you folks prepare it. Okay. And again, I do apologize. This is a little bit disjointed today. I didn't get my normal lead time to review your case. I did review everything that was filed. So I think we've covered everything right now other than the child support, which I'll deal with on the 19th.
So the guardian, the gal will be getting in touch with us, correct?
Correct. She'll reach out to you, and you could probably expect to hear from her within the week at the most. She's pretty quick once she gets the order.
Thank you.
Okay.
Yeah, so we addressed the also the restraining order request.
The restraining order, I'm essentially continuing the one I'll refer to that as in the one that's in the existing order. So terms of that would carry over to this order. And I do have,
and you said,
I do have some proposed orders here, and I'll work on those. I'll make a couple of interlineations to get those corrected so they're in line with what I'm doing.
Okay, and sorry for taking up so much of your time, Your Honor. And we're also sticking to the current the temporary parenting plan is just going to stick to what the protection order is. Correct. At this point.
Correct.
Okay.
And I would say, ma'am, just on the phone call issue, I know that the order says essentially unlimited calls. That probably is overstating what's appropriate under the circumstances. It probably should be, find a time that works for both of you and kind of schedule that so that you're not calling, he's not there. And
I totally understand that, and we do. And
hold on.
Sorry.
And then Mr. Olmos, when it gets scheduled, you need to work around that and make sure that it happens.
Yes, Your Honor, and it is partially my fault because it was my request to allow her to contact the children anytime she wanted. So that was partially my fault. I spoke and I was like, well, I didn't mean every second of the day. So it was partially my fault for me requesting for her to have all the phone calls that she wants.
So here's my thought is maybe you could make a proposal as to what are good times where the kids are available, you're available, she's available, and something you both work out. If you can't sort that out, then we'll come back on the 19th. I'll come up with the schedule you'll be stuck with. So you're probably better off trying to figure that out if you can.
Like I said, Your Honor, it would get canceled every time. And my sponsor is the one who advised me, okay, well, let him know you'll call it this time. Let him know you'll call it this time. And it's consistent. It's been consistent where it's, oh, they're busy, or oh, they're playing with friends, or just all this stuff where he's alienating me out of their lives, and then having.
Let me stop you for a second. First off, you probably. I don't know who your sponsor is. I don't want to know who your sponsor is, but you probably should be getting legal advice from an attorney, because if you call every half an hour when you've got a protection order, that could result in you getting in trouble under the protection order. So you just need to be aware of that. So your legal advice should come from an attorney or somebody like that. before you, because nobody wants you there to be getting in trouble. I just want you to follow the orders so we don't end up back here with problems. Okay, so.
Right, and
so
I
set up.
do.
Yeah, so set up a time and then you both follow through on the time. And like I said, if we can't accommodate that when we come back on the 19th, I'll be happy to come up with a schedule for you.
Yes, Your Honor.
Okay? So
Sounds beautiful.
hopefully moving forward, all of these issues you guys have been having, we'll try and get those under control. And I'm happy to step in if I need to. I just assume not order you to do something that's not going to work for both of you. So see if you can work that out. If you can't work that out, I'll be happy to do that.
Thank you, Your Honor.
All right.
Appreciate your time today.
Right. And ma'am, just for the record, congratulations on making progress in drug court. That's a good thing. Very good thing.
Thank you. Thank you.
All right.
Excited.
I'll get some orders put together. You'll be hearing from Ms. Lawrence, and I'll see you back on the 19th.
Thank you so much, Your
1
Honor.
p.m. Thank you.
You're welcome.